Welcome to Topic 6 lecture, and in this lecture we're going to learn about the right to privacy. In this lecture we're going to define the right to privacy, then we're going to look at where the right to privacy is located in the Constitution, and then we're going to look at three key right to privacy cases: Griswold versus Connecticut, Roe v. Wade, and Dobbs versus Jackson Women's Health Organization. So let's get started. A lot of times when I ask my student what is meant by right to privacy, they'll talk about the Fourth Amendment and police searches, right? They say, hey, the right to privacy is that you have the right to be in your house with your personal effects and that cops can't just bust in to search your home. In many ways, right to privacy is about being free from the Fourth Amendment's being free from unreasonable search and seizure, as is established in the Fourth Amendment of the Bill of Rights. But when we talk about right to privacy in this class, particularly as it relates to reproductive freedom, the right to privacy is more than being free from unreasonable search and seizure. It is a general right. And it is sort of captured by the dissent of Justice Brandeis in a key Fourth Amendment case, which is known as Olmstead versus the United States. And in his dissent, he wrote that essential to the pursuit of happiness is the fundamental right to be left alone. And so when we talk about the right to privacy, it's more than just being free from unreasonable search and seizures. It's really this right that you have to be left alone. So the right to privacy, the right to be left alone, deals with many issues. That it deals with the freedom to make private choices about your family, private choices about how you want to educate your kids, decisions about what schools your kids will go to, and even decisions to a certain extent about the kind of medical treatment your children might receive. The right to privacy is also about making private choices about reproduction. So that's why we're learning about right to privacy in this topic, because the right to privacy applies to the right that you have to be left alone to use contraceptives and to be left alone from government interference as it relates to terminating a pregnancy. It deals with privacy in sexual matters, such as consenting sex between adults. And so the right to privacy, as the court has defined it, applies to the right for people to engage in same-sex sexual conduct, and also the right to marriage, including interracial marriage and also same-sex marriage. And the right to privacy also deals with the right to die, drug testing, whether you can be tested for drug use, and information privacy. So the Constitution of the United States does not explicitly mention the right to privacy. In fact, the word privacy does not appear in the 7 articles in the body of the United States Constitution, and it also does not appear in the first 10 amendments of the United States Constitution. Those amendments are known as the Bill of Rights. And so there's no explicit, a statement that you have a right to privacy. There is an explicit statement that you have a right to exercise your religion. We have the right to freedom of press, the right to bear arms. All of those words are in the Bill of Rights, but the right to privacy is not. So the question is do we really have this right, a right that is not enumerated in the Constitution? And if we do have this right, where does that right originate? In the early 1900s, the Supreme Court creates this thing called the substantive due process doctrine. What that is that it's a legal doctrine that the Constitution protects people from unwarranted government intrusion that infringes upon fundamental rights. So basically, the court is saying that the Constitution in general provides these protections, that if the government is trying to intrude upon what is considered a fundamental right, the government can't do that, whether or not it is expressly stated in the Constitution. The doctrine, it finds its foundations in what is known as the Due Process Clause of the 5th and 14th Amendment. In both of those amendments, it says that no person shall be deprived of life, liberty, or property without due process of law. And so they look at that word liberty and they say, look, it says liberty in the Due Process Clause, but liberty is really not defined. it can be defined according to what the court considers to be fundamental freedoms. And so this sort of opens the door for finding liberties that aren't explicitly stated in the Constitution. So, the substantive due process doctrine implies the existence of fundamental rights that are not enumerated in the Constitution. And in the early part of the 20th century, the court hears certain cases that actually establish rights that are not explicitly stated in the Constitution. In the case Lochner versus New York, that's a case that has to do with New York passed these laws saying that workers, in particular people who worked in bakeries, like large industrial scale bakeries, they said that that's a dangerous job and that those people can't work more than 10 hours a day. And an owner of a bakery said, no, that's not fair. I have a contract between myself and my workers, and if they want to work more than 10 hours a day, they should have the fundamental right to do that. And the court agreed with the owner of the bakery in Lochner. And so they established the right to contract. Now, note, there's nothing in the Constitution that says that you have a right to contract. It's not explicitly stated. But using the substantive due process clause, the court said that that is one of these fundamental liberties. They again in 1923 in the case Meyer versus Nebraska, that has to do with the presence of certain kinds of schools, religious schools, and that there were laws prohibiting the teaching of certain subjects within those religious schools. In that case, they basically said no, that parents have the right to send their kids to the schools that they want to send them to, and the state cannot interfere with the parental right in schooling. Again, establishing a right that's not explicitly stated in the Constitution. The question is the right to privacy going to be one of these fundamental rights that are unstated in the Constitution, but is going to be recognized by the Supreme Court? The question of whether the right to privacy is a fundamental constitutional right comes to the court in the landmark case Griswold versus Connecticut. Griswold, as you'll be reading about in the textbook, is a case about the right to use contraceptives. As you know, that the distribution and information and the use of contraceptives was illegal in the United States, starting in the middle part of the 19th century with the passage of the Comstock Acts. And you'll be reading about that in the textbook. And while some states had gotten rid of these old laws, Connecticut did not, because after the federal law was passed, as you'll learn, a lot of states implemented what were known as the Little Comstock Acts, and Connecticut was one of those states. So in 1965, it was still illegal to distribute and use contraceptives in the state of Connecticut. Estelle Griswold, who's pictured there on the day that the decision of Griswold versus Connecticut was announced in the newspaper, that she was the director of Planned Parenthood in Connecticut, and she challenges the law, saying it violates the right to privacy of married couples. And the court, in a 7-2 decision, agrees, stating that the Connecticut law violates the fundamental right of privacy. Griswold is an incredibly important case because it is the first case that creates and establishes a constitutional right to privacy. Interestingly, it does not use the substantive due process doctrine that we talked about on the previous slides. The reason for that was because Justice Douglas was an opponent of the substantive due process doctrine. It's kind of a controversial doctrine because it basically allowed the courts to pick and choose what they thought were fundamental rights. And so instead, he found the right to privacy, but he didn't find it in the due process clause. Where he found it was in the so-called penumbras or shadows of the Bill of Rights. The decision of the court said that if you take the First, the Third, the Fourth, the Fifth, and the Ninth Amendment together, it's there where you basically find in combination this right to privacy. In the First Amendment, you have the right to associate with others. In the Third Amendment, you have the right to not have soldiers placed in your home. It's the Quartering Act Amendment. Fourth Amendment, the right to be free from unreasonable search and seizure. The Fifth Amendment, the right to remain silent, that there's these private areas of yourself that the government can't interfere with. And the Ninth Amendment is a cool amendment. It says that just because the right's not enumerated or listed in the Constitution doesn't mean that that right does not exist. And so it was in the pulling together of those rights that are in the Bill of Rights that the court found the right to privacy. They say it's a fundamental right, and as such, when the court will apply strict scrutiny in evaluating laws that violate the right to privacy. But there is disagreement, as we're going to see in Roe, as to actually where the right to privacy exists in the Constitution. A major question remains coming out of the decision in Griswold. And that major question is okay, so what is covered by the right to privacy? We know that there is a right to privacy in the Constitution as established in Griswold, but what does it cover? And in particular, does the right to use contraceptives apply to the right to an abortion? And many people were eager to take up this issue. Keep in mind, look at that date. It's in the 1970s. We have a vibrant women's liberation movement taking place in the United States, where there's demands to increase access to abortions, particularly because not having access to abortion can be really harmful to women. They'll still get abortions, but they'll be illegal and unregulated and harmful abortions. And so in 1973, the court answers that question about whether or not the right to privacy applies to the right to have an abortion when it decides to hear the case, the landmark case we're all familiar with, Roe v. Wade. The facts of the case of Roe v. Wade are pretty straightforward. This is a case about a person. Her name is Norma McCorvey. And in 1969, she finds out that she is pregnant with her third child. She's poor. She struggled with addictions, and she really felt like she couldn't provide for another child. So she sought out an abortion. But she lived in the state of Texas, and Texas has a law on the books that prohibits all abortions unless it was necessary to save the life of the mother. And Norma McCorvey's life was not in jeopardy from the pregnancy. And so she was unable to get an abortion. That two lawyers, knowing about the case, said that they would help represent her to challenge the Texas law, basically saying that this Texas law infringes on one's personal right to privacy, the right to get medical care, and the right to have control over the personal autonomy of their body. Uh, uh, so that's who Roe is in Roe v. Wade. They gave her the pseudonym Jane Roe because that this was her to protect her privacies. Now, McCorvey never received an abortion, but she did put the child up for adoption. But it's this landmark case that establishes a fundamental right to have an abortion. As you'll see from the pictures there, that she was initially a pro-choice advocate, and she's there with one of her lawyers that represented her on the left-hand side, who represented her in the case Roe v. Wade. But later, she became an outspoken supporter of the pro-life movement, and you see that on the other side of the slide. The question before the court in Roe v. Wade is whether abortion is a fundamental right under the right to privacy that is established in Griswold. And the answer to that question is yes. The right to an abortion is a fundamental right, and that the Texas law is unconstitutional. The court affirms the right to privacy. They say that it exists in the Constitution, and that they say that it applies to the right to have an abortion. Interestingly, they did not locate this right in the penumbras of the Bill of Rights as they did in Griswold, but in Roe they return to the substantive due process doctrine, and they locate this liberty in the due process clauses. They say that it's a fundamental right, as it is in Griswold, so they affirm that and say that laws that are violating the right to privacy will be given strict scrutiny by the court. However, like all rights, that even fundamental rights, there are limits on the right to have an abortion. So what are the limits on receiving an abortion? Well, in Roe, in the decision, they say that basically as the pregnancy progresses, the interests of the state increase. So Earlier in pregnancy, the right to privacy covers your right to have an abortion. And that right is a decision that pregnant people make with their doctor, and that the state can't interfere with that. However, as the pregnancy goes on and as the fetus comes closer to viability and in fact becomes viable, that is capable of living outside of the human body, that the interests of the state increase. And so that they're sort of balancing the individual rights of privacy against the state's interest in protecting the life of the fetus. And so prior to viability coming out of Roe, pregnant people have an unrestricted right to an abortion. In the second trimester, the state can place more regulations on abortion, but they cannot outlaw abortion. However, after viability, the interests of the state grow and they become compelling, the protecting of viable life, thus opening the door to allow states to prohibit late-term abortions if they so choose. That would not violate the Constitution, prohibiting late-term abortions, according to Roe v. Wade. You'll read more about that in the textbook when it talks about what's known as the trimester framework. Since Roe, the court has heard many cases dealing with laws that restrict access to abortion, but the fundamental right to abortion has always been affirmed and reaffirmed by the court. Planned Parenthood of Southeastern Pennsylvania v. Casey, Casey you'll be reading about in the textbook, is a really good example of that. In Casey, the court says that many sorts of restrictions to abortion, such as waiting periods and informed consent, that all of those are legal sorts of restrictions and regulations that can be placed on abortion. However, the fundamental right to an abortion is still the law of the land. So up until June of 2022, pregnant people had a fundamental right to have an abortion. This, as we all know, ends in the court's decision in Dobbs. Dobbs versus Jackson Women's Health Organization is about a Mississippi law. In 2018, Mississippi passed a law called the Gestational Age Act, and this law prohibits all abortions with few exceptions after 15 weeks. It's the 15-week mark in the law that makes it an interesting and an important law. Fetal viability is usually in the 23rd to the 24-week period. And so prohibiting abortions after 15 weeks is well before fetal viability. And we know in Roe that people have a right to an abortion up until the viability of the fetus. And so the question is a law that like this, that prohibits abortions well prior to fetal viability, is this type of law unconstitutional? Okay, does it violate the fundamental right to privacy as it relates to abortion rights? And the court rules that the law does not violate the Constitution. It was a 6-3 decision, and the opinion of the court was written by Justice Samuel Alito. In the decision, it says that the Constitution does not confer a right to an abortion. And so this decision overturned Roe and Casey. Roe establishes that constitutional right, and Casey affirms that. Both of those decisions are overturned. The ruling says that the abortion, it's not mentioned in the Constitution, that it's a right that's not deeply rooted in the history or the customs of the United States, and therefore it is not a fundamental liberty. And so, as we know, the right to privacy is predicated upon this notion of the substantive due process doctrine, right? That liberty can be expansively defined. And the court in Dobbs basically throws that out and says that that right isn't established, it's not enumerated, it's not expressed in the Constitution, and therefore it is not a right. The decision in Dobbs is the first time in the United States history where a conferred right has been taken away. Usually, the decisions of the Supreme Court expand rights, give people more rights. That is not the case in Dobbs. It takes away a right. So what does this mean for abortion policy in the United States? Well, Post Dobbs, we return to a pre Roe status. In other words, that it really depends on the state that you live in. Prior to Roe, that as it talks about in the textbook, that some states had access to abortion, other states had limited access to abortion. You could get it in the case of rape and incest. Other states, like the state of Texas, couldn't get an abortion unless the pregnant person's life was in jeopardy. And so that the decision in Dobbs really depends on which state you live in. Meaning that there's going to be broad inequalities in abortion access because it depends on the state that you live in. It really remains to be unseen, or remains to be seen what reproductive freedoms will look like in the post-Dobbs world. There's a lot of confusion over what the status of a medically necessary abortion is, right? So, how do we figure out whether a pregnant person's life is actually in jeopardy? That's difficult to determine, thus making it, abortion providers are worried about performing an abortion that might be deemed medically not necessary and that they would be subject to prosecution. There's confusion about whether or not you can travel between two states if your state outlaws abortion, and also the access to medical abortion, that is getting an abortion pill through the mail. We're not sure what the impacts on in vitro fertilization are going to be, and also the role that the federal law can play in codifying Roe. Much remains to be seen in terms of how this is going to play itself out in terms of reproductive freedoms.